The case is now being recorded. Hear ye, hear ye, hear ye. All persons having anything to do before the Honorable, the Justices of the Massachusetts Appeals Court, now sitting at diverse locations within and for the Commonwealth, draw near and give your attention, and you shall be heard. God save the Commonwealth of Massachusetts. Court is open.
Thank you kindly. Good morning and welcome to the Massachusetts Appeals Court.
Good morning, Your Honor.
Good morning. My name is Judge Desmond. Also on the screen in your panel is Judge Grant and Judge Hodgins. I'm not sure where they show up on your screen, so I won't try to point them out to you. We have 6 cases on our list this morning. Our first case will be Zoom, and then the 5 cases. We'll take a brief recess after the first case. We'll move down into the courtroom, and the 5 remaining cases will be in the courtroom. As you may or may not know, Mr. Stubbs, I'm not sure if you've ever done an appeal with the Massachusetts Appeals Court before, but each side gets 15 minutes. It's up to you to use your 15 minutes, however you'd like to use your 15 minutes. We've read your materials. We're familiar with the case. There's no rebuttal. Periodically, you may see us look away from the screen. It's not that we're not paying attention to you, but we have iPads here, we have notes here, we have other materials that we've used in preparation for our sitting this morning, and we may be looking at that and referencing that while we're listening to your argument. So it's no sign of disrespect. It's just that we've got some other things on our desk surrounding us, and so occasionally we may not be making direct eye contact with you. I think that being said, we're good to go. The first matter on our list is 24P0533, the Commonwealth versus Curtis Stubbs. Mr. Stubbs.
Good morning, Your Honor. It must be known that I stand on all of the pleadings that are before you. I'll just give you some insight based on the 3 matters that are before you. And the first matter that I'll give you insight on is the mistrial matter and the 3 deadlocks. Now, during the jurors' deliberations, they were back there for an ample amount of time. They came back deadlocked. And so, Your Honor, Judge Lane gave what he coined was a light Tui Rodriguez instruction. Now, I've never heard of a light Tui Rodriguez instruction. I don't know if Your Honors have, but nevertheless, he gave a light Tui Rodriguez instruction. Now, you can infer that he gave this light Tui Rodriguez instruction because the jurors are back there for an ample amount of time.
Let me ask you this question, Mr. Stubbs. How long had the jury been out before he gave his light Tui instruction?
A few hours, Your Honor. And so the jurors come back. The jurors get sent out again, and they come back deadlocked. And so, Your Honor, I objected and moved for a mistrial. The reason being is because I was under the impression that because a light Tui Rodriguez instruction was given, even though it was light and not full, that triggers the statute. GLC 234A, section 68C. Now, the judge wasn't under that impression. So at this time, the judge deemed that they did in fact do and thoroughly deliberate, and he was going to give the full Tui Rodriguez instruction. And so he asked us, the DA, do you believe that they're that they do what thoroughly deliberated? The DA agreed. They asked if I believe that they would do what thoroughly deliberated. We all agreed. So we're all under the impression that they do what thoroughly deliberated. And so the Judge Lane said, this case may come to a resolution. But if it doesn't come to a resolution, I will declare a mistrial. And so, Your Honor, he sends the jurors back. The jurors come back, deadlocked again. This is the 3rd time. Now, Your Honor, at this moment, he was supposed to look at the bailiffs, and he was supposed to send the bailiffs to get the jurors. He was supposed to pull them up, and he was duty-bound to dismiss them.
Let me stop you there for a second. So, and so far, the facts are undisputed. He determined that they had deliberated for the adequate amount of time. He suggested that he was going to declare a mistrial. He asked the attorneys if they had any objection to that. They did not. He asked the court officer, he instructed the court officer, told the court officer what his plan was. I think the court officer asked if he could have 5 minutes to assemble the jurors. Is that correct?
No, Your Honor.
I see
So,
that in the transcript.
Your Honor, so when the jurors came back deadlocked, the judge was duty bound to tell the buildings to get the jurors and bring them up. Now, when he brings them up, he was duty bound to dismiss them. He had no discretion here.
Did he get a verdict during that period of time?
There should have been no period of time, Your Honor.
I know,
At that moment,
Look, Mr. Stubbs, I understand the argument. I mean, we're talking about the lives of human beings. Okay, so it takes a couple of minutes to get the jurors to bring them back up into the courtroom. The jurors were not in the courtroom, right?
the jurors were back there for a good amount of time. They were sitting back there for a good 10 minutes. So, at that moment, once he received that note, he's supposed to send the bills back there. The bill's supposed to then bring the jurors up there. He was duty bound to dismiss them. He had no discretion here. His only discretion that he had was to seek their consent to continue to deliberate. That was the only discretion that he had.
Did the
Now,
jurors, Mr. Stubbs, did the jurors communicate with the judge on their own? Or did the judge send some communication to the jurors?
Here's the thing, Judge.
No. Did the jurors communicate with the judge on their own, or did the judge send some communication to the jurors? That's my question.
The jurors communicated with the judge, but the thing is, Your Honors, is at that time, he had either dismissed them or the only discretion he had was to seek the consent. Now, this is not a quasi-consent. This is the consent. This is the consent that needs to be sought by the judge. This is the consent where they need instruction. So it has to be consent in open court. You can't give consent.
What do you rely on for that? What case, what are you relying on to support that argument?
GLC section 234A, 68C, it protects me. This is not permissive language. This is a mandate requirement. The judge is duty bound to do this. At that moment, because he deemed them doing thorough and gave the Tui Rodriguez instruction, once that instruction is given and a deadlock comes thereafter, section 234A, 68C says all deliberation is supposed to be seized. The only thing that the judge can do is to call the jurors and dismiss them and seek their consent on record. Now, Your Honor, the judge began to talk to myself and the DA about numerous things that had nothing to do with the case at bar. Now, we're sitting there, he's talking to us for about 10 minutes. There's nothing for us to talk about. We already deemed that they thoroughly deliberated and that if it didn't come to resolution and they come back deadlocked, you would declare a mistrial. Now, while he's talking to us for this 5 to 10 minutes, the judge is sitting back there saying, what's going on? After the first deadlock, he pulls them immediately and gives them instruction. After the second deadlock, he pulls them immediately and gives them instruction. After the third deadlock, he doesn't pull them.
I have a question. I have a question for you, Mr. Stubbs, about your argument about Chapter 234A, Section 68C. It says, if a jury after due and thorough deliberations returns to court without having agreed on a verdict. My question is, did the jury return to court between the time the judge said he was going to declare a mistrial and the time that the jury communicated they had a verdict?
Your Honor, the juries didn't come to court because the judge didn't pull them up. He began to talk to us for 10 minutes. Now, Section 68C says verbatim that it stands guard to prevent jurors from being coerced. You can't leave the jurors down there for 10 minutes wondering what's going on. They sent you 3 deadlocks.
Do you feel that the judge's conduct and somehow was coercive to the jury?
Oh, it was very coercive because after the first deadlock, he pulls them immediately and gives them instruction. After the second deadlock, he pulls them immediately and gives them instruction. After the third deadlock, this is the third time. They're screaming to the court. After the second deadlock, they emphasized on we cannot come to an agreement, underlined 2 times. They say, hey, we had an impasse here.
I understand. Let me ask you this question. After the first time when they sent a note saying that they were at an impasse, did the judge have any conversation with the lawyers before he sent them a note back Or did he, before he brought the jurors into the room, did the judge have any conversation with the attorneys about the note that he had been provided from the jurors?
If it was very brief, but he immediately pulled him after the first deadlock. He immediately pulled him after the second deadlock, after the third deadlock. They sat down and wrote for 10 minutes.
After each deadlock, did the judge have a conversation with the jurors, with the lawyers about that note?
When he pulled the jurors in, we pretty much had the conversation. It was immediate, Your Honor. Now, Section 68C stands guard to prevent jurors from being coerced. This is verbatim. This is a mandate requirement. He's duty bound. The key is, once he deems them doing thorough, that triggers the statute. If he didn't deem them doing thorough, then he had full discretion. His only discretion is to pull them, dismiss them. All deliberations are supposed to be seized. So even if they continue to deliberate, it was against the statute. But the DA here is saying that the statute doesn't matter. It doesn't mean anything. The mandatory requirement doesn't mean anything. Now, I want to refer you to the Karen Reed case. Now, in the Karen Reed case, this is a notable case. In the Karen Reed case, the two-year-old Rodriguez instruction was given. The jurors came back deadlocked. The judge on the bench abided by the legislative intent. She immediately sent the jurors home. She gave Karen Reed her 6th and 12th Amendment, and she gave her an Article 12 Amendment. She received the process that she was due. In my case, the judge didn't abide by the legislative intent. The judge didn't give my 6th and 12th Amendments. He didn't give my Article 12 right. The process that I was due was not given. The only difference between myself and Karen Reed is she's a white woman and I'm a black man. The second case that I want to touch base on is the insufficient evidence.
Mr. Stubbs, wait 1 second. Let me just ask you a question. After the final note was sent by the jury, are you saying that jurors are not permitted to change their minds at that point?
Your Honor, I'm not saying that. GLC 234A Section 68C says that all deliberations are supposed to cease. Once that note comes back deadlocked, after the two-year-old Rodriguez instruction is given, it triggers the statute once the judge deems them doing thorough. So doing thorough means that they have come to their judgment. There's nothing further for them to do. He said it on the bench. If this may come to a resolution, but if it doesn't, I will declare a mistrial. This is the error. He didn't follow the mandate requirement. He didn't follow Section 68C. This is the problem. Now, I want to touch base on the second matter, which is the insufficient evidence. Now, the insufficient evidence, I want to be clear here. My case is devoid of any whatsoever direct evidence connecting me to the case. There's no physical evidence. There's no scientific evidence. There's no video footage of me. There are no witnesses, not one eyewitness. This happened in a busy commercial area in broad daylight. Not one person came to court and said, hey, that is the guy. In fact, the victims themselves said that I was not the assailant. This is their testimony on stand. There's not an iota or a scintilla piece of evidence directly connecting me to the case.
Prior to the victim's testimony at trial, had they previously identified you through any photo array?
They said they were coerced into doing that by the police.
And the jury heard all that, right?
The jury, in fact, heard that, and they heard that a private investigator went to see them prior to, and they told the private investigator they were coerced, and I, in fact, was not the assailant. So the victims themselves said I wasn't the assailant. Now, Your Honor, this is a circumstantial evidence case. This is not substantive evidence. It's not a substantial evidence case, and a circumstantial evidence is completely weak. Now, there is nothing directly connecting me to this crime, Your Honor.
Could the jurors decide to believe what the witnesses said during the photo array and not what they said in court?
Your Honor, no rational trier of fact can convict me and come to a reasonable doubt with the evidence that the Commonwealth presented. There's not an iota or scintilla piece of evidence connecting me to this case directly. Now, to make my point clear, there were 3 deadlocks. There's reasonable doubt written all over this. If that situation was to be rectified the right way and the mandate requirement was to be followed, then this argument would be moot. It would be of no significance because we wouldn't even be here if if GLC 234A, section 68C was abided by.
Let me ask you
Now,
one other question. I see your time's running short. Do you agree that you can be convicted on circumstantial evidence alone? You don't need direct evidence. Do you agree with that?
You can be convicted, but when the circumstantial evidence is completely weak and there's 3 deadlocks and they understand and there's reasonable doubt all over this and they don't understand the instructions, Your Honor, there's not an iota scintilla piece of direct evidence connected to me this. They show that in their 3 deadlocks. There's nothing here. No rational trier of fact can convict me with the evidence that the combo presented.
I
Last
understand.
thing I want to touch base on is the 3rd matter, which is the cross-examination. I was denuded my rights to cross-examine. I was denuded my rights to confront and impeach the Commonwealth's evidence. Now, there's a forensic analyst named Dennis Pierce. Dennis Pierce's job was to take 5 sources of video. He was to put them together and to the Commonwealth's narrative and crop out what they didn't need and leave in what they did need. Now, during the DA's line of questioning, the DA
What were the
says,
videos of?
excuse me?
What were the videos of?
The videos were of different videos from the scene, from the area. They were to crop out and create a narrative of the alleged assailant to put him at the scene and say, this is the person that did it. Now, Your Honor, the DA's line of questioning, the DA says, can you see anybody moving in the car? He answers yes. He says, can you see a license plate? He answers yes. Now the DA asks him, can you tell the difference in complexion from one video to another video? He answers yes. Then she asks him, can you tell the difference in complexion from someone in real life to somebody on the video? He answers yes on the affirmative. Now, this opens up the Pandora's box around him. Now, I go to ask, I say, hey, can you view the license plate? And the judge allows that. Now, this lends credibility to the Commonwealth. So he's allowing this. He just allowed the DA to ask, if you see someone moving in the car, can you see a license plate? I go to say, can you view me in real life? Because he just said that he can tell the difference in complexion between someone in real life and someone in the video. Now, Your Honor, here's the problem here. When I go to ask, the question I was going to ask is, can you see tattoos on the person's neck in the video? The key thing is, I wasn't asking who was on the video. I was asking what was on the video. Just like the DA said, can you see someone moving in the car? The judge completely stops me. He says, I won't allow you to ask anything in particular in regards to what's on the video, but I will allow you to only ask about how Dennis Pierce compiled the videos. He completely refuted himself.
So was your question, is the video capable of capturing tattoos? Or was your question, sir, as you look at that video right now, can you see tattoos on the person's arm or not arm or whatever it was?
Yes, Your Honor, I have tattoos all on my neck clear as day. The person in the video has no tattoos on his neck at all whatsoever. So I was going to ask Dennis Pierce, can you see tattoos on that person's neck? Not who's on the video. I'm asking about a particular. The judge said, I won't allow you to ask anything in particular on the video, but you can just ask about how he compiled it. Now, Detective Ferrari says that I'm the person in the video. So now, the judge doesn't stop him. This is taken as truth. The jurors hear that. That lends credibility. The Commonwealth is taking it as truth. I'm allowed to impeach that evidence, Your Honor.
I understand. Wasn't the judge's position, we don't need the videographer, I'm gonna call him a videographer for lack of a better term. We don't need the videographer to tell us whether or not we can see tattoos on the person, because we're looking at the video, the jurors can look at the video, and they can decide for themselves whether they can see tattoos on that person.
Your Honor, I'm so happy you asked me that question. Here's the thing. What jurors are
Hold on, I can't hear you. Hold on.
I said,
All right. Hold on. Our technology is breaking up a little. Can you hear him?
No.
Hang on 1 second. Matt, is Matt there? Hang on 1 second.
Yeah, if that happens every now and then, I would just like wait 3 seconds and then hopefully Mr. Stubbs can talk and then everyone can hear him again.
Thank you. So I listed maybe the last couple of sentences that you said, so I'm going to ask you to kind of go back a little bit for me, Mr. Stubbs, so that I can.
Can you hear me?
I can.
All right, so I'm happy to answer that question now. Here's the thing. Dennis Pierce testified that his training requires him to have relevant image and forensic analysis training that I don't have, that the jury don't have, that the judge doesn't have. The judge said, hey, we are in no better, he's in no better position than us. He says us, which is completely false. Reason being is because we don't have training in relevant image and forensic analysis training. He testifies that he can tell the difference in complexion from video to video. I can't, he can't, the jurors can't. He can tell the difference in complexion between someone in real life and someone in video. I can't, the jurors can't, he can't. We don't have this training that requires us to have relevant image and video forensic analysis training. The only person here that can tell and testify and go on that video in regards to that is him. If anybody,
I understand. Listen, we have one more question for you. I see that you're out of time. So, but we have one more question for you. So, Justice Grant.
Did you argue in closing that the tattoos were not visible in the video?
Your Honor, there were no tattoos on the person's neck. I was allowed to impeach the Commonwealth's evidence. I was denuded my right to confront
I
the
understand.
witness, and I was denuded my right to.
Hold on, I understand. But the question is, did you argue in closing argument that there were no tattoos depicted on that person in the video? Did you argue that?
Your Honor, I argued, but I needed the credibility of the forensic analyst to be allowed to answer that question. This is the reason. There were 3 deadlocks. That would have been the reason why they would say not guilty.
I understand. So my question calls for a yes or no. Did you argue it or not?
Of course.
Okay. I see you're out of time. We're going to now hear from the district attorney. Thank you kindly, Mr. Stubbs.
All right.
Good morning. May it please the
Okay.
court. Good morning. May it please the court. Kristen Jang for the Commonwealth. And I think I'm going to start with the first issue presented by the defendant in this case. So in my view of the record, I do not see any issues with the way Judge Lang handled these pretty specific and uncommon circumstances here. So,
and while uncommon, Judge Lang did indicate on the record that he had a similar experience with these similar facts. All right, go ahead.
That is true. That is true. I was actually surprised to read that because I don't think anybody in our office at least has encountered these particular circumstances before. But regardless, I don't believe it's disputed, at least directly, that his finding after the first note came in on the first day after the jury had deliberated for only 4 hours inclusive of lunch, Judge Lang's finding that the jury had not yet engaged in due and thorough deliberations at that point, given all the evidence that was presented, the complexity of the issues that were presented at the trial. It's completely within his discretion to make that finding. And then on the second day, after the jury had deliberated for an additional 2 hours, he did find that they had at that point engaged in due and thorough deliberations.
How long was the entire trial, Attorney General?
It was, I believe, 5 days. 5 days total. There were a lot of witnesses. There was evidence of 2 completely unrelated crimes brought in that the jury had to sift through. There was a lot of video, a lot of photographic evidence that the jury had to sift through. So this was a pretty detailed trial. A lot of things for the jury to go through, even though it was just 2 indictments on the same issue, or on the same incident rather. So the judge appropriately and pursuant to the statute gave the full 2E instruction after that additional 2 hours of deliberation. And then 25 minutes later, I think also appropriately, when he received note 3, decided that he did not have discretion really to send the jury back again without their consent. In the 5 minutes that it took to collect the jury and bring them back up, it appears that they had continued to deliberate on their own. The judge had no communications, at least based on the record that we have, did not communicate with the jury in any way after they submitted that note 3. So the only conclusion that could be drawn from that is that the jury continued to deliberate of their own accord, which is completely consistent with the statute.
Mr. Stubbs says, notwithstanding what they did in those 5 minutes since he got the final note, the judge informed the jurors, the judge informed Mr. Stubbs that he was going to declare a mistrial. And so notwithstanding the note that they sent, Mr. Stubbs' position is he should have disregarded that note and he should have stayed the course and declared a mistrial as he informed the parties that he was going to do. What do you say in response to that?
I would say I believe he acted completely appropriately in taking the verdict. I don't think that's in contravention to the statute at all. The statute reads that after the jury returns to court reporting that they cannot reach a verdict after due and thorough deliberations, the judge cannot send them back out again without their consent. That did not happen here. They had not even returned to court yet after submitting that note 3. It was in a few minutes for the judge to just read note 3 to the lawyers, which, as Justice pointed out during during the defendant's argument, he had done the previous 2 notes. It's completely appropriate for him to bring the parties back to court, read the note, decide whether they had the due and thorough deliberations had occurred, and then deciding what to do, explaining what his ruling was going to be, what he intends to do. That's completely appropriate, and he did it the 2 prior times.
I have a question for you about the language of the statute,
Yes.
68C. I'm interested in those words, they shall not be sent out again without their own consent.
Yes.
And I'm interested in the fact that on these facts, at the suggestion of the assistant clerk, Ms. Draper, the clerk polled the jury individually
Yes.
about the verdicts. If one of the jurors had said, no, that's not my verdict, what should the judge have done? Would the judge have to have them decide in the courtroom whether to be sent out again?
That would probably be my suggestion, to see if they consent to being sent out again, because I don't think they could be sent out again to deliberate at that point. And yeah, I believe at that point, and if they do not consent to being sent out again, because that is inconsistent, when they receive a note that they've reached a verdict, the verdict is read, and then you're polling each of the jurors, and that's clearly not a unanimous verdict. So that's sort of inconsistent. So if they did not then consent to being sent out again to further deliberate to kind of resolve that inconsistency, then I believe it would be appropriate to declare a mistrial at that point.
Do you have any cases you're relying on?
I'm sorry?
What's your best case?
My best, unfortunately, there are no cases directly on point. I would just rely on the general cases. Here, let me just pull up my brief on this. Unfortunately, I could not find any published or unpublished cases directly on point. So I would just point to the general cases.
Stubbs says that the Karen Reed case from yesterday helps him. What do you say to that?
I agree with him that the Karen Reed case presented identical circumstances upon Judge Lang receiving note 3. But in the Karen Reed case, at least my understanding of the facts of that case, the jury then didn't, before coming back into court, say that no, they had reached a verdict. So that's the really distinguishing factor here. And I think Judge Lang was very clear that if that had not occurred, we would have had a mistrial here, and we would have had to, potentially retry the case. As to the second issue, I believe in this case, the Commonwealth presented overwhelming evidence that the defendant was the person who committed these 2 robberies. And I think the Reedy case is my strongest case on this point, that a reasonable jury can credit an officer's testimony that a pretrial ID was correct over a recantation that occurs at the trial. And I think that it was very reasonable for the jury to conclude as such in this case. And I think there was really a mountain of other circumstantial evidence to support the verdicts in this case, which I lay out in my brief.
Like what?
Like aside from the pretrial IDs at the photo array, there was also the extensive surveillance footage that was admitted in this case, both the compilation video and the raw footage that the jury was able to view. So the jury could have made their own conclusions looking at the defendant, and the jury had quite a bit of time to observe the defendant during the course of this trial because he represented himself in this case, to compare that to the video. There was also the fact that the defendant's
Hold on one
fiance.
second.
Oh, excuse me,
I
sorry.
couldn't hear you, Judge Grant.
What do you
Okay.
say to the fact that Mr. Stubbs says that the tattoos weren't visible in the video footage?
I just looked at it again myself yesterday. I think it's inconclusive. I see his point, but at the same time, the person on the video is pretty far away from the source of the camera, and just the way that shadows work, I don't think it's conclusive one way or the other. It's not like it was an ATM video where it was, he was directly on camera and you can clearly see the neck in full lighting. So it was a great argument for him to make, and the jury just did not credit it. And he was able to make that argument quite effectively in his closing to that effect. And this kind of blends into the Dennis Pierce argument that he was prohibited from asking the forensic video analyst whether or not tattoos were visible on the person on the video. I think it was appropriate for cross-examination to be limited on that point, but nonetheless, he was fully able to make that argument on cross-examination. So I don't believe he was prejudiced.
But Mr. Pierce was allowed to testify on direct that he could see a license plate, but he's not allowed to be questioned on cross about whether or not he can see tattoos. I don't really get the difference.
So yes, and the defendant makes a good point in that, although I think the license plate is a little different because in the compilation video, there is a point where the license plate is sort of highlighted and then expanded. So I think that point itself goes to the work he did in putting together the compilation video and highlighting why that appears in the compilation video versus his testimony that he was somehow in a better position to see what was on the video. I think it more went to why that was included in the compilation. And I'm happy to answer any other questions on the sufficiency or the cross-examination. And if there are none, I'm happy to rest on my brief as well.
So just so I understand,
Sure.
the license plate arguably was more visible to the viewer than perhaps the tattoos. Is that correct?
Yes, that's correct.
All right. But I don't know of any rule of evidentiary law or process that says, well, if one's clearly can be seen, you can testify to that. But if one's maybe not so clearly can be seen, we can say, no, you can't testify to that. I'm not sure how those two things mesh.
Point taken. And yeah, I don't think he was able to testify about the license plate because it was clear, you could clearly see it. I think it was because it went to the work he did in putting together that compilation video, and as to why it was, well, if you look at it, actually a yellow box, I believe, appears around it and it's expanded. So I think that did not go to what you are or are not able to see on the video. It went to why he did that in the compilation video. And it also went to the police investigation, which was a contested issue in this case, that police unfairly focused on the defendant. So it also went to how they were able to link the defendant to this crime via this vehicle that was registered to his fiance. So I think that is the difference. I agree with you, Your Honor. I don't think it would be appropriate for him to testify as to what he could or could not see on the video unless it went to some sort of technical aspect of the video.
So it doesn't have to do with the fact that he's testifying about the appearance of a person rather than the appearance of a vehicle?
No, I don't believe so. I don't believe so.
So Mr. Stubbs would say, well, how can that be fair? How can it be fair that he can testify about the license plate that links me to the crime, but he can't testify about the tattoos that don't link me to the crime?
I agree. Unfortunately, we're bound by the rules of evidence, which state that what you can and cannot see on a video is a question for the fact finder. And, unless it's admissible for some other reason, which in this case, the license plate was admissible for this other reason of showing how he put together the video and how the defendant was linked to the crime, because that was an issue raised by the defendant. If he had not raised the issue of the investigation and the integrity of the investigation, then maybe that would not have been relevant.
It seems ironic. I mean, what if he tattooed his license plate number on his neck? The witness could testify to what's on the car, but not on the neck?
Well, it depends. I mean, he could have, if it was on his neck and clearly visible, then maybe he would have highlighted that in the video. And then, yes, he could have testified to that because then he manipulated the video in some way to highlight that. So I see the point and I acknowledge the point, but unfortunately, we are still bound by the rules of evidence and what was relevant to the issues in this trial. And I believe admitting the evidence in the license plate was appropriate given the issues, but evidence of what can and cannot be seen on the person appearing in the video was not.
The end of the review is abuse of discretion.
Abuse of discretion as to the cross-examination issue, that is correct. And if there are no further questions, I'm happy to rest on my brief.
Hearing none, the matter stands submitted. Thank you both very much.
Thank you very
Well
much.
argued on both sides. Bear with me one second. Just bear with us one second, Mr. Stubbs. Oh, there we go. Oh. Are we not live streaming now, Matt?
No, we're not.
All right, we'll see you down in the courtroom.
See you downstairs.
Okay, thank you.
Thank you.